Good evening, everyone. I'm Rakhi Gautam from greytHR, the moderator for the session today. Thank you so much for taking out the time and joining us. As you are aware, this webinar is brought to you by greytHR in partnership with ADEX today. So a warm welcome, everyone, once again. Now, before we dive into the session, let me quickly take you all through the agenda. So this session is divided into three parts. The first part will be a presentation by our ADEX spokesperson, which will then be followed by a very insightful discussion with our expert on the topic that we're going to be discussing today, which is Qatar Labour Laws, followed by an audience Q&A. So I can say audience Q&A is where time is all yours, dear attendees. You can start putting across your questions and we will be happy to take them up towards the end. Also, this session is currently being recorded. So if you happen to miss out on anything, do not worry at all. We've got you covered. We will share the recording with you once it is done. And this webinar recording will also be available on greytHR's official YouTube channel. So you can always go there and watch it later. Now, I think we have the quorum to start the session. So before we dive into our topic, which is Qatar Labour Laws, let me quickly invite on virtual stage Mr. Diljit Parayat, General Manager ADEX, for a short presentation. Over to you, Diljit.
Thank you, Raki. Thank you. So I'll be sharing my screen now.
Sure. It's visible. You can proceed ahead.
Okay. So I think it's visible now.
Perfect. Yes.
Yeah. So thank you everyone for joining in. I know 2 p.m. is not the best time for a webinar. I think most of you wouldn't have had the time to have your lunch. But anyway, I'll keep my part very crisp and then we'll move to what we are all here to listen from Emma. So at ADEX, we are actually in Qatar since 2009 and we are basically into IT and security solutions. We help the companies and government and corporate organizations to secure their premises and help in the people mobility solutions. So our solutions in security systems mostly revolve around access management, time attendance management, IP video surveillance, and visitor management. So what we provide the customers with this system is automation of their processes, which controls the access to their premises. We have centralized management if you have multiple locations where you need access or attendance systems to be implemented, complex policies in overtime, absenteeism, late in, early out, etc. And a lot of people are on the move, and we have solutions to provide attendance on the move. Also, our systems are automating the job process costing, where people have multiple tasks that needs to be monitored in terms of the resources that are being spent on such projects, or payroll management, as well as canteen management if you provide food to the staffs. So with those modules, we manage the job and project process management. We get job hours based on payment policies, how much are we spending on those jobs, project status tracking, customizable menu and menu schedule for the canteen, of course, and cashless transactions, as well as food planning. With I'll spend some time on this slide. With this particular integration that we have achieved with greytHR and our attendance module, right from the point where the employee marks the attendance till the salary disbursement is automated process. So in most of the systems, you have attendance capturing, but it is a lot of work for the HR to then consolidate the HR data and produce the pay slips. But with the integration that we have, we can eliminate the extra hassle of paperwork and then push the attendance data by calculating the OT and removing the leave data. So this way, while the payroll is being processed with greytHR, you eliminate a lot of manual hours on HR side. So the payroll is generated and salary is dispersed with the partnership that we have with greytHR and Metrics. Some of the clients that we work in Qatar include the logos you see on the screen. They don't need any explanation or introduction. We operate our offices in all the GCC countries. So we have our offices in UAE, KSA, Oman, and we are serving our customers with greytHR and the metric solutions for their time attendance and payroll processing. So our office address is in Al Sadd, and we are looking forward to listen to Emma in the next 30 to 45 minutes. Thank you, Raki.
Sure. Thank you so much for that, Diljit. That was very quick but insightful, and I hope this helps our audience today who are interested in knowing more about the HRMS solutions that we provide through greytHR. Thank you so much once again. Now, quickly hopping on to what everybody's very highly anticipating for, which is our discussion with Emma. But before we do that, let me just quickly take you all through what is it that you can expect from this discussion today. Can we please have the slide on screen? Thank you so much. So as you know, the topic for today is Qatar Labour Laws, and we will be delving into the recent changes in Qatar labor regulations and the significance for both parties, that's employees as well as employers. We will also be exploring the different types of employment contracts, regulations on working hours, overtime, and rest periods, and main rights and obligations of workers. Our aim is to provide you with actionable insights and best practices to ensure compliance and foster a positive work environment. Whether you are an employer, an HR professional, or an employee, this session will definitely equip you with valuable knowledge to navigate Qatar labor landscape effectively. Now, you would say, Raki, you spoke about a lot of things and with such confidence, right? How are you going to do that? So, to help us decode all of that and to share her insights with us, joining today is Emma Higham. She's the partner at Clyde & Co. Let me quickly take you all through her profile. Emma is an employment and immigration partner with the MEA regional team at Clyde & Co.'s Doha office. Having lived in Qatar for over 18 years, Emma brings a wealth of local experience to her role. Before becoming a lawyer, she worked as an accountant with a Big Four firm. Throughout her extensive career in the region, she has played a key role in clients' growth and strategic planning. Emma's practice encompasses all aspects of Qatar employment and immigration law, covering both the state and the QFC. She also manages a diverse global mobility immigration practice, assisting multinational clients with all facets of their personal mobilization schemes, including dependents. Once again, thank you so much for joining us today, Emma. It's a pleasure to host you.
It's my pleasure to be here. Thank you very much for such a lovely introduction.
Thank you, Emma. And let's start. I think we can start with our very first question, which is, of course, to set the context of this session today. What are the most significant recent changes in Qatar's labor laws, and how do they impact both employers as well as employees?
Cool. So we talk about recent changes in the labour law in Qatar. So I think I'm just going to set the scene a little bit. So actually, I've been in Qatar for 20 years. On Sunday, I celebrated my 20 years in Qatar. And when I landed in Qatar, one of the first things I was given was a brand new labour law. So, and I found it today for this. So this is the labour law that you can't really see, but I picked up from the Ministry of Labour in 2005. Now, we call it the new labour law. It's actually Law 14 of 2004, but it replaced Law 3 of 1962. And that is why we call it the new labour law. Now, basically, this law is the law we have today. you know, there have been various changes to it. Some of the changes basically are to say the Ministry of Labour will now be called the Ministry of Labour Administrative Development. The Ministry of Labour will change its name, etc. We had in 2004 we had a new amendment to Article 66, which was the wage protection system. That was the introduction. We had in 2014 as well a change to Article 3, which extended the exemption for the oil and gas sector. But the main changes that people are talking about were actually 2 years, sorry, they were actually 4 years ago now. They came in during COVID. So we had Law 17 of 2020, Law 18 of 2020, and Law 19 of 2020. So I'm just going to look at those laws a little bit, because those are the changes that people talk about when they talk about the recent changes. I think everyone forgets COVID, you know, that whole 2.5 years was just, you know, put it to one side. And actually, we've got the recent changes. So Law 17 of 2020 brought in the minimum wage. So before that law, we had a temporary minimum wage, which was 750 rials a month. Lots of people wanted it to be increased to 1,200, but actually at the end of the day, the first guideline that was issued under 17 of 2020 set the minimum wage to 1,000 rials a month, and it set allowances, accommodation to 500 and food allowance to 300 minimum if the employer didn't provide accommodation and food adequately. Now, there's no definition of what adequate means. And what we've recently had, interestingly, is when people are trying to attest their employees' e-government contracts with the Ministry of Labour, and we'll talk a bit more about e-government contracts in a minute, what we're finding is that even if people have got a basic salary of, say, 15,000 a month, i.e. far more than the 18,000 that is the minimum provided for in law, the guidelines under Law 17 of 2020, the ministry official is coming back saying, you haven't included food allowance. Where's the 300 rials? So we've got a very black and white approach currently to the application of these minimum salaries in the context of the attestation of the Ministry of Labour, the attestation by the Ministry of Labour. And this will change over time for sure. But I just wanted to highlight that a lot of our clients are a bit perplexed. They're like, well, why when I'm paying someone 45,000 rials a month, am I having to pay them 300 rials food allowance sort of thing? Now, the option obviously is to put provided in the e-government contract, but actually we've got quite a few employees who are then coming forward saying, okay, well, now you need to provide me with food every day. So there's a little bit of mismatch at the moment, but it will settle in time for sure. Now, I'm going to look at Article 9, Law 19 of 2020 next, because Law 18 of 2020 is the big change. 19 of 2020 was a law that changed our immigration law. So our immigration law is Law 21 of 2015. There were various laws after that law implementing various bits, for instance, no exit permits. So Law 19 of 2020 was the last. Now, what that was meant to do was, amongst other things, it was meant to get rid of letters of no objection. Now, we'll talk a bit later, but everyone on this call will know that during the first Eid break in Qatar, a new employment transfer process was brought in, whereby transfer applications need to be processed through the National Address System, the NAS portal. And what that now requires is that the new employer will upload the transfer. The employee will go in and approve the terms of the transfer, and then the current, the old employer will also have to renew through the portal for the transfer. So we've lots of people have said it's like going back into the dark ages, leading up to the World Cup. Very much there was going to be, free movement, free liquidity in relation to the labour market. And that didn't happen. And we all know that NOCs were usually required. But with this active approval of the transfer in the portal, and that's actually an active act that needs to take place. And I think a lot of people see that as really NOCs coming back into Qatar. Now, you know, our law says that we shouldn't need an NOC. There's a law in Oman and a law in Saudi that says exactly the same thing. But interestingly, in those jurisdictions, we all still need NOC. So it's not like Qatar is totally out on its own in still having those restrictions. It's just that I think people were hoping, you know, the monitors and the charities that are active in Qatar were probably hoping for a bit more. So, you know, 19 of 2020 did a lot of different things, but we don't have very much time today. But that one of the main things was to finalize the implementation of our immigration law in terms of free movement, no exit permits required, etc. So going to law 18 of 2020, that is the biggest change really, apart from the, you know, wage protection system introduction. I've picked out three main provisions of the law that I think are noteworthy, but obviously there are various others. So the first one is in relation to probation. So before law 18 of 2020 took effect, probation was, which is Article 39, it was, so what is probation? So probation is a single period of up to 6 months. So that isn't 2 periods, that isn't 3 months that can be extended for 3 months. It is 6 months. And if you want the opportunity to reduce it earlier, you should say it's a 6-month probation period that may be terminated early if performance is in order, something like that. So we've got up to 6 months of probation. And in the olden days, only the employer could terminate with reduced notice, and the notice was 3 days written notice. And the only reason you can terminate employment during probation is for poor performance, in effect. After this new law took effect, we've got a real change in the landscape. And I, for one, would argue that actually people probably shouldn't have a probation period anymore at all. What we now have is 6 months, a single period of 6 months. An employer can still terminate for poor, but actually the only reason still that an employer can terminate is for poor performance. It's now 1 month's notice in writing. The difference now is that an employee can terminate with 1 month's notice in writing, but either just because they want to transfer their employment or because they want to be repatriated. So what you've really got is a situation here where the employee during probation has the ultimate power, because they can terminate for really any reason, but the employer is restricted to poor performance. The other scenario is that the notice period is now the same notice period as for during probation and after probation. And this is why I'm saying, do you really want probation? Because from an employer point of view, you might want to terminate for a reason other than poor performance. You can't do that during probation, but your employee can terminate if they want to be repatriated or if they want to transfer employment, which is exactly the same as after probation. But it's just something to think about. Some of my clients say, oh yeah, I'm not going to have probation anymore. And some of them say, no, I want probation. I've always had probation. It's very important to me. And that's fine as well. So probation, that's a big difference, I think. And then, so that's Article 39 and then Article 49. So we've always had in Qatar the fact that you can terminate on notice for no reason. Now, prior to Law 18/2020 taking effect, you could terminate for no reason only if you had an indefinite contract. It wasn't after probation, so it could be at any time. So from day one of employment, either party could give 1 month's notice to terminate for no reason. So fixed term contracts were not included in the ability to give notice under Article 49. What we now have is a situation where, in order to terminate and for no reason, you have to have finished probation. Another reason perhaps not to have probation. You've got to have finished probation, and it can be either any term contract, arguably, because it doesn't include the word indefinite anymore. So that is quite a big change. There is also therefore an argument whether or not fixed term contracts actually exist anymore. The other thing to think about is that in the past, you would terminate with 1 month's notice if employment was 5 years or less, and with 2 months' notice if employment was more than 2 years, more than 5 years. But now you have that 5-year period has been dropped to 2 years. So it's 1 month's notice before 2 years and 2 months after. Now, can you increase notice? Can you increase notice? For instance, both parties agree that it will be 3 months' notice. Again, that's quite a tricky one. So in the past, you could do that and it was enforced. But what we're seeing now with the new transfer process is the employee, if the employee wants to give notice, they might say, well, hold on, I don't want to work for you for 3 months. I actually only want to work for 2 months. And you are unfairly restricting me by trying to enforce 3 months. And we're seeing the Ministry of Labour agree to that position. It's causing problems with people at schools because obviously they might have a term for notice. So it's just one of those things to think about, that we're seeing in the new transfer process real adherence to the labour law in terms of the 1 month, 2 months. And then the third thing I wanted to mention about Law 18 of 2020 was a change in the post-termination restrictions. So before this law, we had an ability to restrict somebody for 2 years in the law. That was practically applied by the NOC. Now, what the new law gives us is they reduce the 2 years to 1 year. And what it also is very clear, it says that basically it sets out that the termination restriction must be reasonable, and it says how that can be reasonable. And in summary, it means that you can't compete or do business with an entity that is in the same business or is in competition. And in effect, it means in Qatar, because actually practically, how do you enforce? I see a lot of post-termination restrictions that say anywhere in the GCC. So apart from the fact that it's pretty unfair, how would you enforce it? Finally, it says that the agreement for that post-termination restriction, the agreement must be in writing. Now, in the e-government contract, which we're talking about, but we will talk about in more detail when we answer the next question, there is no place in that e-government contract to deal with post-termination restrictions. So employers must ask employees to sign a separate agreement that sits alongside the e-government contract or the international contract or internal contract, if it wants to rely on that in order to object, for instance, to an employment transfer. So that's a long way of saying we're sitting with the same law that we've had for the last 20 years. There have been some minor and some major changes, but the ones we're sitting with at the moment from a labour law perspective really are the changes that came in for Law 18 of 2020.
Okay, thank you so much for that, Emma. That was very comprehensive, and I think this pretty much sums up what we are discussing today, right? Thank you so much for all those insights that you shared. And I think what you also mentioned was the main point is about the probation period, which has been changed from what was it before, and that's one of the major changes that's happened. Okay, so thank you for that, Emma. Moving on to quickly my next question, which is, what are the different types of employment contracts that are there in Qatar, and how does the type of contract affect the rights and obligations of both employers and employees as they move along?
Cool. Yes. Okay. So, well, the operative contract in Qatar is the Ministry of Labour standard form online e-government employment contract. That's a big mouthful. So let's call it the e-gov contract. This really came in 2016, and very slowly, as people's RPs have been renewed and their employment has been transferred, pretty much everyone now has an e-government contract. Why did we have an e-government contract? Because beforehand we had a pretty good dual language Ministry of Labour contract. The reason for putting it online was twofold. One, it then slots into the wage protection system, because obviously, you know, if you work, you should get paid. And secondly, we now have in Qatar the Qatar visa centres, so 8 countries where the nationals must go back to their home country in order to complete their medicals and their fingerprints before they come into Qatar with residence permits. There's lots of different reasons why we have the Qatar visa centres. We have them in the countries where the most of the working population come from. So India, Philippines, Nepalese, Sri Lanka, etc. In addition, you know, from a human rights perspective, it means that people have signed their employment contracts with their employer before they come into Qatar. You know, in the past, there was absolute horror stories where people thought they were going to work for Carrefour, and they ended up, you know, for Carrefour, I don't know, earning 750,000 riyals a month, and they ended up on a construction site earning 500 riyals a month. So, so the Qatar visa centres, you know, have come about, and the e-government contract then underpins the ability to sign a contract outside the country and be paid once you come into the country. Now, under the old dual language Ministry of Labour contracts, we used to be able to put a lot of detail in, to the point where even some of my very senior client employees just had a Ministry of Labour dual language contract, because you could put in a different paragraph. You could put in, you know, maybe you couldn't put in 5 pages of intellectual property, you know, protection, but you could put in a paragraph. And so we had a lot of employees in Qatar at the time with just one contract. When the e-government contract came in, it's obviously just a page. I know they say there's an annex you could fill in, but actually we have confirmed recently with the Ministry of Labour, you can submit an annex, but they will not review it. They are only going to attest the e-gov contract. So because of that, most employees now in Qatar, bar blue-collar workers, are given, I would say it's an internal contract or an international contract. It's usually in English, and it gives you more information about your rights, terms of employment than you would get in the e-government contract. Now, the terms in the internal contract should not, they should mirror the e-government contract, because if a dispute arises, the Ministry of Labour and the judge at the Labour Disputes Committee will always go to the e-government contract first. It will then look at any other document. It will ignore anything that breaches the labour law, and it will cherry pick all the goodies that enhance the benefits of the employee. Now, just looking at the e-gov and the internal, and we already talked about whether or not fixed term contracts still exist, and that is still open for debate. But the law still refers to fixed term contracts in Article 40. So what I would say is a fixed term contract is a contract that starts on the 1st of January, for instance, and it finishes on the 31st of December, and no notice needs to be given. An indefinite contract starts on the 1st of January and continues until it is terminated in accordance with its terms or notice is given. Now, what we have had in Qatar in the past are a lot of, I don't know how you define them, but what it will really say is on the first page, it will say, this contract will start on the 1st of January and it will finish on the 31st of December, full stop. But then in clause 8, it will say, either party can give notice to terminate this employment contract at any time. Now, before our law changed, 18th of 2022, an employee would go to the court or the Labour Disputes Committee and say, ignore the fact that there's notice in my employment contract. This employment contract is for 1 year. And on that basis, the employee would usually be given the unexpired term. What we're seeing now, and there is precedent in the QFC and in the state, what we're seeing now is people are saying, whatever contract you've got, if there is notice, that is notice that both parties have agreed in advance to terminate the contract early. So if you've got a notice period in your employment contract now, you will not be able to enforce the fixed term. Can you enforce a fixed term if there is no notice period? I don't know the answer to that question. I wouldn't suggest that any of my clients or any of the employers on this call seek to rely on that. And obviously you've got the International Labour Office here, you've got Amnesty International, you've got everyone saying that people shouldn't anyway be held to a fixed term contract because it's modern slavery, et cetera, et cetera, et cetera. I mean, not in those terms, but you know what I mean? They're just advocating for people being able to leave work when they want to. So that's the different types, I would say, of employment contract we're dealing with in Qatar at the moment.
Sure. Thank you so much for that, Emma. That definitely helps, because I think this is one of the most frequently asked questions. What are the different type of contracts are there in Qatar, and under which contract do I fall into? And is it going to be beneficial for me or not? It is also very important. So thank you so much for this, Emma. Quickly moving on to my next question, which is, if you could explain us about the standard working hours defined by Qatari labor laws, and how's overtime regulated, including any compensation requirements as well.
Okay, right. So the labour law states that the maximum working week is 48 hours. And then it talks about 8 hours a day. So we know that it is by implication talking about a 6-day working week. And probably in Qatar today, the majority of employees will work a 6-day working week, split shifts. So they will work from 8:30 till 1 and 4 till 8. More and more, however, we're getting white collar workers in, and it doesn't quite work like that. People are working a 5-day week. So what I often see is people saying, okay, you're working a 5-day week, so we're going to split the 48 hours into 5 days. That doesn't work, because the labour law is specific. It talks about a maximum of 8 hours a day. No, and that's 8 hours whether or not you work a 6-day week or a 5-day week. It's just that legally, if you work a 5-day week, your employees should not work more than 40 hours basic. Now, the labour law also says that the employee can work 2 hours, a maximum of 2 hours extra overtime a day, i.e. 10 hours a day. Now, there are exemptions. So the main exemption is a managerial exemption. Now, how do you define your manager is a big question. If you go to the Ministry of Labour and you talk to them, they'll often say that they think a manager under the law, i.e. a person that applies, can make managerial decisions about an employee, is somebody that appears on the commercial registration and somebody who appears on the establishment card. It's a very, very narrow definition. Now, you get the other extreme that I see, and I was talking to Luigi, the head of the Employment Standards Office, last year. We often see like manager of drivers, manager of pantries, Luigi said. Now, if a manager of a driver is somebody who should get overtime, he shouldn't not get overtime, and calling him a manager doesn't suddenly make him somebody who is exempt from being paid overtime. For me, a manager is somewhere in the middle. It's somebody like a middle manager, somebody who's professional, somebody who can decide the hours that they work. Because what we always have to look at is, what is the Qatar Labour Law trying to do? It's trying to protect the employee. It's a good law. It's enforced badly, but it's in good, and we've got lots of naughty employers in Qatar. But actually, the labour law is trying to say, if somebody, it's trying to say that an employee should only have to work 8 hours a day to earn their salary. And they're trying to say that if somebody comes along and says, you are working extra hours today, that employee has the right to be paid overtime. For me, if I get up on Friday morning and think I'm going to work all day, that's my choice. No one's telling me to do that. And I think that's the idea that we need to get to. However, you have to be very clear in your contracts and your policies who is going to get paid overtime and when. Policies are very important. Overtime is expensive. We'll talk about the calculation in a minute, but I would always put in a policy, subject to receiving written confirmation and approval, overtime will be paid. So you don't just have people not working on a Monday and Tuesday, working on a Friday, on a rest day and getting paid overtime, for instance. So managerial is one exemption. You've also got emergency. And then you've got like security guards, preparatory work, etc. Now, what those exemptions mean is that people can work more than 2 hours overtime. But the overtime still needs to be paid. So you might have somebody working 14 hours a day because of an emergency. But after 8 hours, that person needs to be paid. Also, you work 8 hours a day and actually you shouldn't work more than 5 hours without a break, etc., etc. So that there's all those different things to do. Now, there's lots of different ways to calculate how you pay overtime. So I think that if you go to the Ministry of Labour, what they'll say is you take a month's basic salary, let's say it's 30,000, well, let's say it's, I don't know, 10,000 basic, you divide by 30 because those are the days in the month and you get paid for every day. You divide by 30 and you divide by 8 and that gives you your basic salary. Now, if you look at some websites, some charity websites and some NGO websites, you'll see that they divide by 26. That gives you a higher value of overtime pay. They divide by 26 because they say that the person isn't working for the 4 days, the 4 rest days within that 30-day period. I don't know if I agree with that or not, but that's why you might see the difference. Now, how is overtime paid? Well, if you work in excess of your 8 hours, you get paid an uplift of 25% of basic salary, i.e. that amount that we've just calculated. It will be times 125. If you work between the hours of 9 p.m. and 3 a.m., then that uplift is 50%. Now, if you are a shift worker, you won't, and your employer has had its shifts approved, then you will, and that's approval at the Ministry of Labour, then you will not be paid the extra 50%. You'll be paid the 25%, but not the 50%. Yeah, so that is, let me have a look at the question again. So that's the standard working hours. We've talked about 6 days, 5 days. How is overtime regulated? You really need to, record it, but I would always get written approval. I think that's very important. And we've talked about how it's compensated and who gets what and who is exempt. So I think I've covered that question.
Definitely does. Thank you so much, Emma, for that comprehensive response. Just quickly moving on to my next question, because we also have a lot of questions and audience are also sharing a lot of questions. So we'll come to your questions as well. But before we do that, we talked about different types of employment contracts. We talked about, overtime. We talked about, of course, the recent changes. But of course, with all of this comes what are the fundamental rights of workers in Qatar. And they, of course, would also have obligations, towards their employers as well. So if you could just define that for us.
Yes, and actually the first 3 questions had the chunkiest answers, so we'll be able to wiggle through these quite quickly. So the fundamental rights of workers are to be paid, I would say, are to be employed in accordance with the labour law and to be paid. And the obligations of workers towards their employers are obviously to do the work. Both in accordance with, the labour law. We have the Qatar Constitution, which some people argue only applies to category nationals. I don't think it does. If you read it, what it basically is talking about all the people in Qatar. So people need to be treated fairly. They need to be treated with respect. Employers should have an overarching obligation to provide a safe working environment. But that's what we're talking about when we talk about fundamental rights: do the work properly and be paid properly, which of course the e-government contract and the wage protection system is meant to achieve.
Definitely. Thank you for that, Emma. Now, you did touch upon, being treating your employees fairly, and there should be transparent laws and your policies. So, what are, like, if anybody is facing such as, issues such as discrimination, harassment, or unfair dismissal, how are these addressed in this new Qatari labor laws?
Yeah, so interestingly, discrimination in Qatar it's addressed in the constitution, and we do have some regulations that deal with people with disabilities, etc. But the main, we've got the fact that if you've got juveniles working, they can only work certain hours. But the main provision in the labour law is in relation to women. So what it basically says is that women doing the same job as a man should be paid the same. And then and obviously we've got all the maternity provisions. So I mean, I would say that's sort of the main crux from an employment perspective. Harassment is a tricky one, because we don't have anything in the labour law that deals with harassment. I mean, they recently brought in some provisions in the UAE, for instance, although it's not clear how these would be enforced. I mean, really, harassment in Qatar is dealt with in the penal code. It's more of a criminal offence. So it's important to have policies in place, and maybe to explain exactly what you mean by harassment. I mean, sexual harassment, for instance, for sure, is in the realms of the criminal rather than within the labour law. Unfair dismissal, so we don't have arbitrary in Qatar, but like unfair or wrongful, I would say it's wrongful dismissal. So that, the bottom line is, if you've got an issue, you should be dealing with it within by appealing to internally first, then going to the Ministry of Labour and submitting a complaint. Now, what happens if you do that is an SMS will go to the PRO or the immigration signatory for your employer, and they will be called to the Ministry of Labour. We've got a client who's just contacted us today. They have been called to the Ministry of Labour, so we are looking at documents to try and work out what this person's complaining about. And if one of the parties isn't happy, usually the employee isn't happy with the meeting that goes on at the Ministry of Labour, then they can ask for an escalation for their case to be held heard in front of a judge at the Labour Disputes Committee. And that those are the main ways that discrimination, harassment, and wrongful dismissal sort of appear and are dealt with in Qatar.
Sure. Thank you so much for that, Emma. Moving on to my next question, which is more like a follow-up only, which is, what steps can employers take to ensure that they're fully compliant with Qatar labor laws, and what are common compliance challenges that they might face, and how do they, overcome that?
So what lots of people say to me, I do quite a lot of training, and people say, where can I get a labour law, that's, totally full, I can rely on? The answer is nowhere, really. The laws in Qatar are issued in Arabic. There's no official translations. And when we talk about Law 14 of 2004, 17 of 2020, 18 of 2020, none of them have been integrated. Now, I'm quite lucky. Clyde & Co. has various subscriptions. And when we get an amendment to the labour law, I am given a law that everything is merged in, and it's highlighted in a different colour, and I know, so I'll look at my labour law and I can see it came from Law 18 of 2020. So it's tricky. There are so many lawyers and HR specialists in Qatar. I urge people, you don't have to come to Clyde & Co or me, but go to somebody to work out, before you decide to do some major restructuring, you do really need to be sure of your facts. And so it is, so to ensure they're fully compliant, you need to try and keep up with the laws somehow. follow LexisNexis or somebody else. I did a training the other day. There were 32 people there. It was in-person training, and 18 people put their hands up to say that they're still paying 3 days written notice. They're still giving 3 days written notice for probation terminations. Yeah, it's been 4 years. So so you need to keep abreast, and you need to, be aware. I mean, if you look at Qatar Living, for instance, they might give you the wrong information, but they certainly highlight when there's a change. So you really do need a good HR person, actually, someone robust that can, that monitor what's going on. I think that's very important. Common compliance challenges are the mindset, especially as we have more and more white collar workers. The challenges I see are that people are pushing back on the labour law. They don't see the labour law as being appropriate for them. Schools complain because, the annual leave is big. The oil and gas sector complain. They want to pay hourly rates. They want to pay day rates. They don't want to pay the components. They don't want to pay end of service gratuity. So they make it part of a day rate. But then if they go to the Labour Disputes Committee, the Labour Disputes Committee will always award end of service gratuity. So those are the challenges I see, are that the labour law, as our market, as our employment market becomes more sophisticated, the labour law doesn't work for quite a few of our sectors any longer. And it's having somebody that doesn't shout about it, but it's having somebody working for you that works out how to deal with it, how to work within the grey area, such that the employees are happy and the employers get what they want.
Definitely. Thank you for that, Emma. Now, a follow-up question to this, of course, is what are the penalties for non-compliance with Qatar Labour Laws for employers, especially?
Yeah, I mean, that's sort of quite easy. The penalties are set out in Articles 143 to 146. There's no great shakes there. The biggest penalty, the biggest two penalties really, are breach of the wage protection system for not paying. Quite rightly, I mean, I believe that people should be paid for the work they do. And the other penalty, which came in 18 of 2020, certainly in the run-up to the World Cup, is about accommodation. The fines for not providing adequate accommodation to your employees are huge, 100,000 riyals, and there's imprisonment. So I would say there's lots of little penalties, 2,000 for this, 5,000 for this, in the labour law. And there's others in the immigration law, things like holding on to people's passports when you don't need them, things like that. But in the labour law, we're really talking about WPS and accommodation, because there are associated criminal penalties with those as well.
Sure. Thank you for that, Emma. I'm sure that helps our audience today. My last question to you would be for the employees. Now, whenever we face a difficult situation where, we might be a little fearful of what we should do next, right? Because that's a natural human reaction, right? So when it comes to employees also, and if they are facing some sort of discrimination or wrongful dismissal, or they want to just seek legal assistance or report violations for these labor laws in Qatar, how can they do that? And are there any specific laws that protect them or protect the whistleblowers majorly there in Qatar?
I don't mean sound negative, but not really. It will depend on the internal policy. So some of my clients have got very sophisticated policies about grievances. If they're in the Qatar Financial Centre, you need a grievance policy in place and a disciplinary policy. And in the state now, you see a lot of grievance and disciplinary policies taking effect and going through. Now, you've got ultimately Article 49, depending on the term of your contract, i.e. you could terminate someone for no reason. So, if you raise the flag and you say something that's, not appropriate, then you can lose your job. But I think that's the same in many other countries. Actually, in England, if you made a nuisance for yourself, actually they'd find a way, to terminate your employment. But if there are policies, then it's key to follow them. confidentiality. You need to be sure of confidentiality. Now, if it doesn't work within the firm, we've already talked, we've got the complaint to the Ministry of Labour and we've got the claim to the Labour Disputes Committee. Labour Disputes Committee, very, very employee-centric and favours the employee. The issue is, though, that the court will put you as an employee, they will put you in the position that you would have been if the employer had paid you correctly. So if you say something and someone thinks, oh, I'm just going to get rid of that person, they terminate with 1 month's notice or 2 months' notice, and they pay in full, end of service gratuity, everything. At that point in time, then the judge won't award anything else, because they just won't award anything else because they just want to make sure you've been paid in full. Now, my last point about whistleblowers, be careful. We are seeing whistleblowing policies coming into Qatar, there's no question. But we have very onerous defamation laws in Qatar. So if I say something to you, Ricky, even if I say something about you, I say that you stole something, and I say it to a third party, and I can prove that you did, but because I've said it to a third party and they might think badly about you, you have a personal criminal claim against me. So you do have to be careful. The other thing in Qatar is that if you find out when a whistleblowing line, you find out about a criminal offence, under our penal code, there is an obligation to report that criminal offence, at which point in time, you can't protect the person from an anonymous point of view. So you do have to and then you've also got a moral dilemma. So you do have to be careful when you put your policies in place to try and give the employee an ability to make a grievance. You have to be careful what you promise them in terms of confidentiality, etc., etc.
Sure. Thank you so much for that, Emma. This was definitely very insightful, a lot to take from this conversation today. And, I think we covered pretty much everything. But as you said in the beginning, there's a lot more to, discuss and debate upon, which I'm sure, our audience would like a lot. But considering the time that we have in our hands today, this was still a very comprehensive discussion today with you. Thank you so much for joining us once again. And now, as promised in the beginning, we're just going to take quickly the audience questions that are there. We will try to cover as many as we can. But this is for the audience. What we're going to do after this webinar is by next week, we should be sharing the recording of this webinar with all of you, along with Emma's LinkedIn profile or email ID. We'll check with Emma on that. And, you can connect with Emma personally directly as well. If you are there in Qatar, if you need any legal advice or you want to connect with Emma, I'm sure she would be, happy to do that. So we'll share all the information with you afterwards next week, and you can connect there. But in the meantime, we'll just take all the questions that are there. So the first question is Article 57. Upon termination of the service of the worker, the employer shall at his cost return him to the place. Does that mean termination by both parties, employee as well as employer?
Yes. If you bring somebody into Qatar on a work permit, it's your obligation to return them to their place. Now, that obligation moves if an employee transfers between employers, but it means that the end employer is always obliged to repatriate the employee when they finally leave Qatar.
Sure. Thanks, Emma, for that. I hope that answers the question for you. Moving on to the next question, which is, I think this was when we were discussing about the probation change that's coming. So are we saying that there is a choice for company to choose with probation or without at all?
Yeah, currently in the government contracts, you can put a 0 for probation. Now, from time to time, they won't accept a 0. They might say you need to do 1 month or something like that. So yeah, but at the moment, there is definitely a choice.
Okay. Moving on to the next question, which is, what should be the minimum housing, food, and transport allowance as per the law?
So Law 17 of 2020 and the first guideline only referred to housing and food. It didn't refer to transport. But of course, in the past, we always had to have transport. So the housing is 500 and food is 300, but it's only if it's not provided adequately. So what you'll find is a lot of e-government contracts will have a basic salary, and you'll find that they put in provided for housing and food. The only issue I would say there is if an employer or employee or lots of employees come back and go, okay, so where's my housing and where's my food? So you do need to be careful. It's something that a lot of PROs do. They can't get the employment contract tested, so they stick in provided when they really should go back to the HR person and say, hey, I can't get attested. Are you okay if I put in housing and food? Because, you know, it seems like a good thing to do at the time, but I have seen a group of employees come back and, you know, insist on the fact that they have lunch bought for them every day.
Okay. Moving on to the next question, which is, we did discuss upon this quite in length, but if you would just maybe like to highlight it once again. What is the law for termination during probation notice?
Law 18 of 2020. That's the amendments into Law 14 of 2004.
Okay. Moving on to the next question, which is paying time in lieu is okay instead of paying in cash?
So that's an interesting question. So, the law previously was silent in relation to pay in lieu. So I would always say it should be in an internal policy or a contract if you want to do it. Law Article 39 for probation and now 49 for notice actually says in the penalty section that if either party do not honour notice, then they will compensate the other party for basic salary. So what this really means is if an employee or, you know, if notice is given and the employee doesn't work for 2 weeks of the notice period, he or she will not be paid for those 2 weeks, and they will have to pay back an amount equal to the basic salary for those 2 weeks to the employer. But if the employer doesn't honour it, i.e. by paying in lieu, and I don't really agree with this, but the guy at the Ministry of Labour said, well, that's what the law says. It sounds to me like the employer can say to the employee, I'm giving you notice for 2 months. I'm going to pay you in lieu. And actually, I'm only going to pay you basic. So what I would say to you is if you want to do that in your policy or your internal employment contract, you should put it in bold and underline it because it's onerous.
Sure. Okay, thank you for that. I hope that answers the question. Moving on to the next one, which is, this is more like a rapid fire that we're doing, but we want to, you know, cover as many questions as we can. So this question is from Mariam. Hello. If per internal policy we have flexible and do not enforce overtime and rely on the coordination between the manager and the team member to provide time off in lieu of extra hours, do we still have to pay overtime nonetheless?
Look, the bottom line is you can do that. That's fine. The problem you'll have is if somebody makes a complaint or files a claim, you will not be able to enforce that arrangement. The judge will look at the black letter of the law and apply it. So, Mariam, if you can manage it internally, that is great. But you do need to watch for the employee who potentially might make a claim.
Okay. Next question is from Victor. Do you have to provide proof that the employee was unable to perform tasks on the termination during probation?
Yes, you do. And so it is, that's why I'm saying it's onerous. You've got 6 months. You need to tell the employee what they're meant to do. You need to, you know, review it after 2 months, review it after 4 months, and then just say, actually, it's not going very well. So it's active. You can't get to the end of 6 months and say to an employee, actually, you're not performing well, because they'll go, well, hold on, you could have told me that last month and I could have done something about it. So you do have to manage that exit for poor performance during probation. Or actually, you need to manage it for anything on exit. You need to manage it so the employee is aware, because what you want to do is to have an easy exit. You don't want an argument.
Sure. Thank you for that, Emma. Next question is, this is more like a statement to confirm. There is no unfair dismissal compensation. So only remedy is reinstatement.
Yeah, I mean, lots and lots of local lawyers will ask for. They will ask for just 1 second.
Sure.
I realise that I've got another call that's just started at 3 o'clock, so I've just sent him a message. Yeah, so people will ask for damages, but in my experience, what will be provided is they will put you in the position you should have been if the contract was exercised properly.
Okay, we're just going to take a couple of last questions and then we wrap up the session. So this question is, for overtime payment, does that need to be compensated in cash or salary, or can be paid in time in lieu?
It's the same point that I made before. The law says it should be paid in cash, but if you want to manage it internally and you don't think there's going to be a dispute, then you can do that.
Okay. So one last question, which is, when the employee did 3 times offense and the company terminate, is he or she entitled for the end of service?
The only reason you wouldn't be entitled for end of service is if you were terminated under Article 61 for gross misconduct. Under Article 59, you might actually go through a disciplinary, and they might say that you shouldn't get end of service gratuity, but that would need to be in a policy and it would need to be explained very clearly and be transparent.
Sure. Thank you so much for that, Emma. With that, we are done with all the questions. This was a very insightful conversation today. Thank you so much once again for taking out the time and joining us.
It's an absolute pleasure. Thank you, everyone, for your attention and questions.
Thank you. So as we have come to the end of the session, as we said in the beginning, this recording will be shared with all of you, and this will also be uploaded on greytHR YouTube channel. So, you are free to watch it later as well and come to take all the notes that Emma just shared with us today. Also, if you have any questions related to greytHR or otherwise, you can write to us on the email ID, which is there on the screen. That's yasser.arafat@greytip.com, and we will get back to you. So once again, thank you so much, everybody, for joining us. Thank you so much, Emma, once again for the session, and of course, Diljit from ADEX for making this webinar possible, and of course, all the attendees, because we can do a lot of sessions, discussions, but until we get this kind of participation, it's never really successful, right? So thank you, everybody who participated today and made this a successful event. Thank you once again.
Bye-bye.
Thank you. Good evening.